the
I believe we're
shell there and the regular rectangle. And it's the same depth as all the other lots in the subdivision. The only,
I'd like to call the regularly scheduled meeting of the Collegedale Board of Zoning Appeals in session. I am not normally here. I'm secretary to the board, and since the chair woman is not present this evening, I'm going to open the meeting and then ask the two remaining members to vote on a chair to lead the meeting this evening. And I will entertain a motion.
I move Todd be the chairman. Temporary.
Second that. So tonight's meeting pro tem chair will be Todd Lehman, and I will turn the meeting over to him at this point.
I'll go ahead and call us to order. Will you call the roll, please?
Chairwoman Gray, Member Moody,
Here.
Member Lehman,
Here. Okay, after roll call, we have reading and approval of the minutes from the previous meeting. If you've looked at those, I'll entertain a motion.
I move
Oh.
it be approved.
Okay, I have a motion. I guess I can second as chair, right? Since I have to.
Under these circumstances, yes.
Okay, I second. Okay, approval of the minutes, roll call, please.
Member Moody,
Yay.
Member Lehman,
Yes. Motion carries for the minutes. We have no items on old business. We have 3 cases on new business having to do with front setback reductions for 3 different lots in Wesley subdivision phase 4. I guess, will we go through those one at a time, or do you want to do those collectively and then us vote individually, or?
We can do these collectively, and then an individual vote is appropriate since they are 3 individual cases, because they do pertain to 3 individual lots.
Okay, go ahead, Mr. Martin, if you would.
The lots in question are depicted on the projector over here, and you did have these in your handout. And it involves these 3 lots in Wellesley Phase 4, lots 179, 180, and 181. This is a community lot here. The orientation is north and south. As you can see the north arrow here, so north and south, east and west. So basically east, southeast of the lot 181 is the community lot, and then of course 178 lies to the north or the northwest of the lots in question. This is a closer look, which was also included. This was from the petitioner's grading plan. As you can see here, the lots we just discussed in the community lot. You can see the grading plan and the contours here to get an idea of the slope. We also do have photographs of the site. So beginning with BZA 2022-1, this is lot 179. This is the street view looking to the south. That's Chestnut Cove subdivision in the background. This is looking roughly east along the rear property lines of the subject lots. This area down here is the community lot. It's where the slope becomes much steeper at the edge of the picture. And so this is Chestnut Cove here, and the street is over to your left. This is roughly the same view, but this is taken from the the easternmost lot, 181 at the community lot, looking roughly to the west. You can see the lot lines would be roughly running this way. And 180 is essentially very similar, looking to the south. That is Chestnut Cove subdivision. And then the view, so you're looking roughly right here. And then, of course, that lot is going to be roughly in that area. And then the final lot, 181, we're just moving steadily east along the street. So this is 181. Over here is the community lot. And so virtually the same view down here. And so actually this is a long 181 right here. And so that reflects the grading plan that you just viewed. And so that is essentially the quick site specific information. The size of the property, each lot is approximately 8,100 square feet. The current zoning is R1H, high density single family residential district, which does allow lots of that size and this use. The property was rezoned from AG to agricultural in around 2006. And this is the final phase of the Wellesley subdivision. The rest of this property, the Wellesley subdivision, is also zoned the same thing. Previous subdivision history, a preliminary plat was approved by the Collegedale Municipal Planning Commission February 13th, 2017. And this one, after that plat was approved, grading plans were approved by the city, and then a final plat was approved by the Collegedale Municipal Planning Commission on January 10th, 2022, which created all of the lots in Phase 4, including the 3 that are the subject of the variance request. The final plat was recorded with Hamilton County Register of Deeds on February 10th. Plat book 123-112 is the page. So that essentially, upon recording, that did create the lots. It was out of a larger tract of land, obviously. The rear portion of the properties, and the applicant can speak to this a little more clearly than we can, but there is a drainage swale in the rear of the properties here. And the elevation changes per the grading plan, roughly on lot 181 particularly, is changes from about 840 feet above mean sea level in the rear southeastern corner to approximately 856 at the street. The elevation change occurs over the length of that lot, around 108 feet along the eastern lot of the boundary. So adjacent zoning to the north, all of these are zoned R1H, just like the subject properties here. To the south, it is R1, low density single family, and this is in unincorporated Hamilton County. To the east, the community lot is also zoned R1H, and then of course to the west, lot 178 is zoned R1H. So the adjacent land uses are virtually the same. These are all vacant at this time. However, the lots to the south are built with single family residential structures on them. So the utilities for the subdivision, site checks, installation appears complete and nearly, or for utility installation, streets, base pave, binder, curb and gutter, drainage in progress. There's a completion bond with the city to complete any necessary work. Site grading is largely complete, although staff did notice earth moving activity during March 7th, 2022 site visit. And some building permits have already been pulled for other lots within the subdivision. As you see, the question before you tonight is a front setback variance. The base zone R1H specifies a 25-foot front setback. The petitioner is asking for a 20-foot setback instead. And that is the only variance that is requested for these 3 lots tonight. And standard for variances, including in your packet. So staff analyzed the site and determined that each of the lots, particularly let's start with 179, that under the criteria of the state law allows, staff finds that lot 180 was platted as a part of the Wellesley subdivision phase 4, which was recorded Hamilton County Register of Deeds as we discussed. However, we did not see that it was exceptionally narrow or shallow or of irregular shape. In fact, all the lots are uniform in size, more or less, along this stretch. There are no exceptional topographic conditions, and strict application of the zoning ordinance does not result in a peculiar or practical difficulty or undue hardship on the owner. And that is the first finding that the staff, or they're not the finding, but the analysis. Second, that the relief of these peculiar hardships, practical difficulties or undue hardships granted by the Board of Zoning Appeals would not constitute a substantial detriment to the public good or substantially impair the intent and purpose of the zoning ordinance. That's the question under state law. Staff finds that granting the variance would constitute substantial detriment to the public good or substantially impair the intent and purposes of the zoning ordinance. Third question, that the peculiar hardship, practical difficulties, or undue hardship would apply to the particular land or building regardless of the owner. Staff finds that the peculiar hardship, practical difficulties, or undue hardship would apply to the particular land or building regardless of the owner, if such conditions were deemed applicable in this case. So, moving to fourth question, that the peculiar hardship, practical difficulties, or undue hardship is not created as the result of an act upon the part of the applicant. Staff finds that the peculiar hardship, practical difficulty, or undue hardship is created as a result of or an act on the part of the applicant, particularly in respect to the applicant's desire to use a slab-on-grade foundation. And the fifth, that the peculiar hardship, practical difficulties, or undue hardship asserted by the applicant relate only to the premises for the benefit of which the variance or special exception sought and would not generally be applicable to other premises in the city or the personal conditions of the applicant. We feel that this current, that the peculiar hardship, practical difficulties, or undue hardships experienced by the applicant in the current instance are the same as other property owners would experience under the same conditions. So those are some of the convoluted questions that state law requires us to answer in regard to a variance request such as this. And the request was made for each of these lots, and the reason was the same for each. The request is for, and this is from the application, request for a reduction of the required front setback from 25 feet to 20 feet, the topography of the lot and the depth of the lot combined to create the hardship for which the variance is being requested. The new lot grading is required to tie back to the existing grades at the rear of the lot, which reduces the buildable depth of the buildable area within the lot for the slab-on-grade design home proposed for this lot. So we feel that the insistence on a slab-on-grade home type is a choice and would apply only to the applicant because it is the choice that the applicant requests. However, we feel that these three lots are not unbuildable under their current conditions. So that is essentially the staff's findings and recommendation.
Okay, thank you, Kelly. Do you have any questions for staff?
No.
And the applicant is present tonight, of course.
Okay, if the applicant wants to come forward and give your name and address. And then are y'all in opposition or are you part of the opposition? Okay, great. We'll hear from you next. Thank you.
Mike Price, MAP Engineers, 7380 Applegate Lane, Chattanooga, Tennessee. So I'd like to go over a couple of the items as it relates to staff's findings. So, but before I do that, let me just state that there are some items here that I'm not certain were considered in the manner in terms of where we started versus where we are today. And what I mean by that is this. The site was a challenge from the beginning. There's some 120 foot of grade difference from one end of the site to the other. So the extreme topography that we faced was in the very beginning. We didn't create the topography. It's been that way, I guess, since God created the earth. But when we went in and graded the site, we were able to create many, many lots that are very, very flat and usable today. However, we weren't able to achieve that on all of the lots. So to state that there are no exceptional topographic conditions ignores the fact that we had to go in and grade the site in a manner to even make it usable, but we weren't able to make every lot in through there practical in terms of being able to use it. Can you build on every lot? Absolutely. Whether it's slab on grade or whether it is a crawl space is irrelevant. It's still a challenge on some of these lots. So don't take that this is a self-created situation as much as it is, it's ameliorated, and we've taken an extremely difficult site and created many lots. We just couldn't create all of them. So I would take exception to number one, that there are no exceptional topographic conditions. There were from the very beginning. We just weren't able to correct them all. The second is that granting the variance would constitute a, quote, substantial detriment to the public good or substantially impair the intent and purpose of the zoning ordinance. I would like clarification. How exactly does this detriment to the public good or substantially impair the intent and purpose of the zoning ordinance? If I could get, I guess, clarification on that.
Well, generally, the ordinance has been 25 feet, and I mean, not generally, but the ordinance has been 25 feet for other projects that have involved a massive amount of clearing. And the concern that the city has, and it has been a long-standing one, is that a lesser setback creates a condition where there is vehicular overhang from driveways into the sidewalk and walking path. And that is one of the reasons for the setback for this type of housing. We have lesser setbacks, but that's for a different housing type with rear-loaded garages. So 25 feet is generally the rule for this type of product.
And that would have been my guess. And what we have found is, as long as we maintain 20 feet, the cars do not overhang into the sidewalk area. We've gotten many variances at the city of Chattanooga. There are many ordinances, not only in Chattanooga, but Hamilton County and other counties as well, and cities, that 20 foot is your minimum sometimes. And you don't end up with that situation occurring where you're overhanging into the sidewalk. So I can completely agree. We do not want cars overhanging into the sidewalk, and granting a 5-foot variance, our experience has been that will not create a impediment to people being able to enjoy walking up and down the sidewalk. So I don't see that this is a detriment to either the public or the intent of the ordinance, which is to step your homes far enough away off of the right of way so that you don't have cars backing up into your sidewalk area. We'll also be able to meet the ADA requirements that are so called for that Collegedale has as it relates to the driveway slopes. So keeping the 2% until you basically get behind the back of the sidewalk. So I don't see that we're violating item number 2 as it relates to that. It looks like on number 3 that there is not an issue here because this particular situation is not something that we that you would apply to this particular land regardless of the owner. So that is whether we're building it or someone else for building it. So the last one or the next one is number 4 is not created as a result of an act upon the applicant. Again, we took the site 120 foot of grade change in just in one direction. If you look at the other way, it sort of was a ridge top. So we were faced with grades going in basically 3 different directions. We graded the site in a way that eliminated many of those. If you look at the, say, 214, 215, 213, all those lots, and there's others that are on the rest of the site, we've eliminated those in terms of having a problem, whether, again, it's a crawl space or slab on grade, they're flat. So we've fixed so much of this site. We just had a couple that were difficult in nature to deal with. The last one is that the peculiar hardship, practical difficulties, or undue hardships asserted by the applicant relate only to the premises for the benefit of which the variance or special exemption sought, and would not generally be applicable to other premises in the city or the personal conditions of the applicant. So again, the hardship was created from the very beginning just by the topography. And we can still build the same house. I'm not going to say you cannot build a house if this board was not to grant the variance. I don't think that's really the issue at hand. It's the difficulty at which to agree is what the builder needs to do. Lot 181 clearly has quite a bit of topography change, and we have the community lot that's to the right of that. So there's not a house that will be constructed there. But what we did not want to do is to step one house forward and have the other 2 houses sort of be out of character with regards to being 5 foot further in. So we asked for the 3. The intent being is to basically sort of step 179 just a couple of feet back, 180 a couple, 2.5, 3 feet back, and then 181 be at 5 feet back. So if you're walking through there on a sidewalk, either up or down, in front of these homes, you don't just go, oh, wait a second, these houses are pulled forward. It would basically blend into what the setbacks are for the other homes in through here. So I think unless somebody can show otherwise, I think we've demonstrated that this is not going to create a public hazard, does not gut the intent of the zoning ordinance, that it's simply a matter of when we took all the grades of all the lots in through here, these became the three problem children, call it, and that the rest of the site, there may be another lot which is not on here like 189, but these were basically the three. So that's the request, is that these three be granted variance. If you want to step those back in terms of, in 179 to 181, we would certainly be agreeable to that if that was the board's conclusion. If there's any questions, be happy to answer.
Okay, thank you. Do you have any questions?
First, if I have a real difficult time with the idea of granting variances on a brand new subdivision. That's like saying that you weren't capable of designing the subdivision to handle the construction it was intended for. And this really doesn't set well. And you did design the subdivision, you designed the grading. So you created the grade that we have there. And the only real difficulty to build there is to put it on slab on grade and basically save some money by being, a cheaper type construction.
Whether it's slab on grade or crawl space, it's the same situation. We're still falling out in the back. And the other thing I would point out is so one of the things that we looked at was, could we do like a PUD overlay? But the zoning regulations don't let us go to a PUD, which would have allowed us to go to a lesser setback. So in talking with staff, our only course of action was to take it to this body. So I didn't have a zoning PUD overlay like typically I might find in other jurisdictions where I could implement that and then take care of it holistically, so to speak. So in this instance, this is our only option.
Okay. And I'm assuming we had some opposition, so anybody that would like to speak, if you want to come on up and I'm assuming are y'all both also here on? Okay, so completely, I got you.
They live in Chestnut Cove,
Gotcha.
and I'm the treasurer of Wellesley Homeowners
Okay.
Association.
Okay, well, if you'll give your name and address, thank you, sir.
Stephen R. Beckham. I live at 9684 Regency Court in the first little cul-de-sac street in Wellesley, Phase 1. But I've been an officer for, I don't know, 17 years or something. I can't really address the merits, but what my concern, or what our concern is that the restrictive covenants for our subdivision also require a 25-foot setback. And there is and I can give you a copy of those if you would like to see that language. There is additional language that says this requirement may be waived by developer if in its sole discretion determines that any such waiver shall be in the best interest of the subdivision. The definition of developer changed when the HOA was formed, and the covenants have been amended to replace developer with board of directors of the HOA. And we didn't hear anything about this until a couple of days ago.
Well, and let me only say this body has no jurisdiction over covenants and restrictions that are a part of the deed. But you bring up a great point because so even if it's granted from a variance perspective and it's in violation of covenants and restrictions, that becomes a legal issue that the person may be able to do. But we don't have any jurisdiction over those covenants.
I understand that, but we have not only have we not been asked to approve, we haven't even been notified.
No, and that's important
And
information
didn't
for us
have
to
the
talk about.
information except for the original application package, which had the justification as something to us was extremely vague, and it was clarified somewhat tonight. But our board hasn't had a chance to consider that. So we don't know what position we would take on it, except that we support the staff's recommendation at this point. I don't think I have anything else to add.
I'm assuming that all the other, I mean, and I think what you would state, all the other homes within that Wesley Place development are 25-foot setback
They
on the
all
front.
conform. And you know, there are other, of course, other restrictions in the covenants, such as we require a lot of either brick or stone or stucco on the fronts of the houses. And the builder has acknowledged that they need to comply with that in phase 4. So that's our job. Part of our job is to enforce our covenants. And yet we weren't even consulted about this request.
No, thank you very much. Appreciate that. Did y'all want to speak on? Okay, thank you. Mr. Price, you're the applicant. I think, do we do the same process we do? Do we allow any response or?
Yes, you can call at any time
Okay.
the applicant to clarify and rebut, and staff as well.
And you may not want to make any comments relative to the covenants and restrictions. So if you want to speak one more time before we at least deliberate, please do.
Thank you. So I guess at the end of the day, you have to get one before the other. So I guess we need to see what this body says before we would pursue what course of action we would take from here.
Thank you. Do you have any questions for either the applicant, opposition, or staff?
Pretty much clear on it. I mean, I just, like I said, I find it very difficult to grant variances on a brand new subdivision, that they created the situation that by design. I moved to deny it.
Okay, and I'll second. Roll call.
Member Moody,
Yay.
Member Lehman,
Yes. Okay. Do we need to, let me back up. I'm assuming we need to make a motion for each individual.
If you find
case.
the conditions apply to each of those lots,
Well,
then each one would need to have a separate motion and vote.
okay, well,
Um,
I'm assuming the justification for the motion is the hardship was created as part of the development. And the requirement is a 25-foot setback, which we're going to be consistent with. And so there was a motion. Let's take that motion. If it's agreeable to you, it's agreeable to me as second, that motion and approval without, it would be for BZA 202201, which was lot 179, if that's agreeable to you. And do we need to make 2 additional motions?
Yes, please.
Okay.
I moved for lot 180 to also be denied.
Okay, so we have a motion for BZA 202202, motion to deny. I second. Roll call.
Member Moody,
Yes.
Member Lehman,
Yes. And we'll entertain a motion for lot 181, BZA 202203.
Move it, lot 81, 181 be denied also.
A second. Roll call.
Member Moody,
Yes.
Member Lehman,
Yes. Okay. Seeing that is all of our new business, is there doesn't appear to be any other business? Okay. Without objection, we'll be adjourned.